Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we at Digital Law are a niche law firm specialising and working solely in the technology and cybersecurity law sector. In each episode, we look at recent stories in the news relating to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we're covering this week, check the links in our show notes. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleague Peter. I'll let Peter introduce himself and then we'll get started.
Hi everyone, my name's Peter. I'm a solicitor and the managing director at Digital Law, and given that we've got a lot of stories to get through, I'll pass back to Amelia.
Thanks, Peter. So yes, firstly the story titles. So we'll be covering the MOD data breach investigation, VPNs being the top downloaded charts as age verification law kicks in, 1Password is all it takes to end a 158-year-old business, Fiona forwards client details to his personal address, McDonalds AI Hiring Bot, and the UK government's new relationship with Google. But before we dive into today's stories, here is some background information on our podcast provider, Anson Evaluate. Anson Evaluate are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialising in advising clients over multiple jurisdictions. So, kicking off with our first story of today and looking at the MOD's data breach investigation. And I think every man and his dog has heard about this at this point because it has been everywhere.
Indeed.
So essentially in August 2023, the MOD was made aware that an excerpt of a spreadsheet related to applicants for its Afghan relocations and assistance policy was circulating online. The MOD reported the matter to the ICO within 72 hours as required by law. The MOD immediately began an internal investigation into the matter, which determined that the spreadsheet initially shared in 2022 and thought to contain data related to a small number of applicants had contained hidden data relating to more than 18,000 people. So you can see here, this is not a small matter and quite a big issue to have come out. In relation to what the ICO have said, they have said the following. We've supported the MOD with its internal investigation and carefully considered the specific circumstances under which the breach occurred, including the critical need to share data urgently in this situation. We're reassured that the MOD's investigation has resulted in taking necessary steps and minimised the risk of this happening again. We have also considered the proportionality of further action while the MOD rightfully takes steps to protect those most affected. We are satisfied that no further regulatory action is required at this time in this case. We are keeping this under review and may choose to revisit this decision at any time if new information comes to light. So essentially, the long and short of it is the ICO are not going to do anything specific about this due to changes that the MOD have allegedly made. Peter.
Yes, and what we're looking at here is the specific side of this story from the data breach angle. The wider nature of this story is that after all this happened, and it's now happened in 2022, so 3 years ago, the only reason this is being talked about now is because it was subject to a super injunction, and that super injunction was finally no longer renewed any further by the High Court a couple of weeks back, and therefore the journalists at the Times who'd found out about this breach but then were unable to report on it were then finally able to do so. There's been a lot of ramifications then over the fact that because of the danger to life for these individuals, there's then been a government resettlement scheme. There was then, after this story first appeared a couple of weeks back, it appears there may then have been retaliations carried out by the Taliban in Afghanistan on the relatives of individuals named in this breach. So it looks like the security reason for why the super injunction was in place may indeed have been entirely valid. Clearly, reasons of national security would have been as justification in court for why a super injunction, such a draconian level of secrecy, was necessary, and it looks like that was indeed warranted based on what's happened. Let's look at this though. Let's park all of that to one side and look at this from the data breach perspective. I think the first thing is the fact that this confirms that it is the practice across government for spreadsheets to be used for very large data sets. In this instance, we're talking about, I think the figure you gave there, Amelia, and we're quoting this directly from the ICO's press release on this.
Yes, so 18,000 people. And
yes.
Let's not forget that, of course, we are looking at high-risk scenario. You've got Afghan relocations and assistance policy. So we are going to be looking at what you could arguably say was a special category of personal data, because in identifying these individuals, there is a risk to life, as you've already identified. So, automatically there should be a higher level of care taken with this sort of information. While I appreciate, obviously, this data needed to be shared urgently, there is a balance that needs to be found in protecting it while still being able to share it.
This actually, and this is just it goes to a cultural point on the culture within, I think, these large government departments. So we know that a few years ago, when COVID testing first happened at speed during the pandemic, apparently the UK government COVID test results were being recorded on a single spreadsheet. And it turns out that when you scroll down on a spreadsheet and it seems to be infinite, it isn't infinite, because the government found that after a few million entries, it did run out.
Well, it looks like someone has to try and test how far it goes.
Exactly. Like over was a million, or something like 350,000, I think, was the limit, which is immense, of course. But it just shows that spreadsheets are not really the suitable vehicle for these sorts of data sets. It wasn't suitable when it came to doing COVID testing. And it was not suitable in this instance when it was being used for, Afghan relocation. And there should have been, at a certain point, an individual was asked to open this spreadsheet for this purpose.
Yeah.
And clearly, they were not in a position to be able to turn around and say, this isn't a very good idea. As you just said, it is obvious to someone who works in data that when you're looking at sensitive data of this type, a spreadsheet would not be a good vehicle for bulk storage of that information.
Absolutely not.
Certainly not a good medium to transfer and send that information. So it is inherently not a good idea to be using a spreadsheet for that purpose. There are other more secure systems available out there. You would argue that an organisation like the MOD in this instance, with the breadth of its resources, would have secure systems that would allow for the secure processing of this data. That wouldn't mean they all go on a spreadsheet.
One would think.
And clearly, as I say, there is the culture whereby, because it's usually then some poor junior at the coalface who's told, right, open this spreadsheet, start dumping data into it. They did not, even if they did have reservations, they did not feel that they were in a culture where they can turn around and blow the whistle and say, no, this is stupid.
Yeah.
Because they've probably been told by someone who in turn has been told by someone higher, who in turn has been told by someone higher that this is what has to happen, therefore just do it. It's very often the culture in these big lumbering bureaucracies, and no one can actually turn around and go, no, this is ridiculous. It's the sort of behaviour that simply, I like to think this wouldn't happen in the private sector. I don't know for sure, but I think that if you're used to using technology and you're used to looking at the issues around bulk data processing, you would instantly go, loads of red flags, this isn't the right vehicle to do it.
Absolutely. And I think we can probably just leave our discussion there, because otherwise we'll end up going down the political minefield, which I don't think we've got long enough to even explore in the next couple of weeks.
No.
So moving on to another massive story that's been hitting the headlines, and that's the fact that VPNs are the top download. They have topped download charts as age verification laws kick in the UK. So VPN stands for Virtual Private Network, and they've become the most downloaded on Apple's App Store in the UK after sites such as Pornhub, Reddit, and X began requiring age verification of users on Friday. So VPNs can disguise your location online, allowing you to use the internet as though you were in another country. So, for example, in the UK, we could pretend that we were in Australia. There you go. It means that people are likely using them to bypass the requirements of the Online Safety Act, which mandated platforms with certain adult content to start checking the age of users. This is because before it was essentially the question of, are you over 18? It was a yes or no, and there was no sort of nothing else to it. Whether you're 18 or not, you could just press the yes, I am 18, thank you very much, and view whatever content you're after. But very easily this can be circumvented, as we are apparently seeing. And for those that did not realise it could be circumvented, it's now all over the news. So well done.
Isn't this like one of the top 10 stories on the BBC News website today?
Literally.
I think. Yeah, it's there. So yeah, anyone who didn't know this now knows it. So the story saying, look, record numbers of VPNs are being downloaded will be encouraging the record downloading of more VPNs. Who'd have thought it?
Yeah.
You know. So yes, the blindingly obvious thing that was always going to happen has happened. We have talked at length about the Online Safety Act on this podcast. We talked about it when it was the Online Safety Bill. We've talked about a lot of the, I think, very valid concerns that campaigners have had around use of social media and mobile devices by minors. And child is defined in the UK as below the age of 13. And we certainly recognise the very valid concerns that parents, that campaign groups have got. However, I think we've always been sceptical that a big piece of legislation drafted in the UK Parliament was necessarily going to be the best way to handle it. By definition, we keep on seeing laws that are drafted that do not really reflect the technology that they are trying to regulate. And the glaring thing that was always going to happen was if the UK said, right, we demand that the platforms do blah, 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 and impose restrictions on users based in the UK, all you would have to do is download a VPN, and surprise, surprise, that's what the great British public is now continuing to do. If anything, this is actually showing how tech literate the UK viewership is.
Well, and this is kind of a big but that I'm going to say here. There's tech literacy, but also the fact that it is free VPNs that's topping the charts, not paid for VPNs.
Yeah.
And unfortunately, that therefore means that there are some significant security concerns and cybersecurity concerns about the use of these free VPNs because, they're not specifically regulated. You're going to then have potentially your data exploited if you're then using these.
Many of these VPNs are based overseas themselves and not subject to any UK regulation. Not that there is any meaningful UK regulation of VPNs, but the point is that the VPN itself that you might be downloading to your device could be hoovering up just as much personal data as the average invasive social media app or dodgy site. These things are, you're downloading and putting something on there from a third party, and who knows what that will be doing. Some of these VPNs, not all VPNs are equal. Some are more equal than others. I mean, there has been a spike in use of NordVPN, which is the premium one, that's a popular one that's advertised all over the place, and the usage of that is going up. But for those who don't want to put their hand in the pocket and have just gone, oh, I want to get one for free, yes, it's thousands of these freebie ones that are being downloaded as well. And these are the ones that you can't necessarily be sure on the veracity of the product and whether you aren't, by downloading one of these, are you not actually exposing yourself to an even bigger risk? That is the concern.
Then you've got the increase of risk if, bad actors are saying, well, crikey, in the UK, everyone's downloading free VPNs. Well, there's a lovely little bit of useful information that they can use to then create their own VPN to then target you.
Yeah.
Because, that is a really, really good opportunity for them to harvest information.
Exactly.
So there's a lot of reasons why there's a giant big hole in the Online Safety Act and what it was aiming to achieve.
Yeah.
And actually, in terms of, from a cybersecurity standpoint, literally is causing more problems.
Yeah. And there'll be, unfortunately, this isn't the last of the Online Safety Act you've heard, folks. There is going to be more of this. There is the steady drip feed of the powers that are in the Act gradually coming into force. And a lot of this is driven by the fact that Ofcom is the regulator that is gradually being given more and more powers under the Act as they come online. So Ofcom's been given more of a budget. It's probably not enough of a budget to actually effectively use the powers that it's got, but nonetheless, it will be starting to, as different laws then come in, it will be, in theory, looking to regulate and enforce. Indeed, we were looking before we started recording, we started to think, well, how does this work with a platform like X, which obviously has millions of EU and UK users, has a lot of content on there that is not suitable for minors, and how is that going to verify age? And I think they've already said that this could lead to certain platforms being blocked in the UK, because there are some platforms that will not bend the knee and impose age verification.
But then there's the flip side as well. Is where do you draw that line in terms of what is
harmful?
What is harmful? What is adult content? Because you could argue that some news stories are adult content, but then is it not important for children to understand? For example, what's going on in Gaza? You know, there is a lot of information out there about that. Some of that very, very distressing to the viewership. But then you get into the territory of freedom of speech and freedom of information. Why should we be telling people, particularly in relation to news, what they can and cannot view?
And this is just it. You do get it's scary world out there, and increasingly more scary. So very often, when certain things happen, there can be quite upsetting scenes. From war zones around the world, and indeed sometimes, a public demonstration, you can see some signs that are held up that can be a little bit close to the bone, shall we say.
Oh, you saw clips recently circulating about one of the reporters that got hit with a rubber bullet during a demonstration. You literally saw that live on camera, and to some that might be incredibly distressing. And that's readily available.
And indeed, some of these platforms encourage live streaming, and then sometimes you find live streaming. I mean, this happened, I think, when there was the terror attacks in New Zealand a few years ago. The terrorists live streamed what they were doing on a social media platform. I mean, eventually the footage was taken down, but it meant that people on those who saw that were pretty traumatizing, seeing people being killed. Funnily enough, to anyone, be it adult or child.
And it's just, where do you draw that line? It'll be interesting to see how far this draconian sort of law actually ends up going, and whether it gets repealed, because if it is not doing what it sets out to achieve, it'd be interesting to see what the outcome is, because there is a lot of people that are not happy.
Well, I mean, when we used to do training for the European Law Students Association, sometimes we'd go and deliver training for these groups of fantastic young would-be lawyers who are training and full of optimism and about what future legal practice will be like. And sometimes we'd say, as an exercise, we'd do a workshop on draft your own legislation to clamp down on hate speech. And guess what? They always found it was impossible. And if a room full of young lawyers can work that out, why can't our legislators work that one out? It is literally one of these things. It is kind of impossible to draft. And the Online Safety Act spent years being drafted and amended and fiddled with, and going back and forth from Commons to the Lords and back again, and committees and back again. And what, the sausage that eventually come out of the machine is very, very far from perfect. And what we've seen this weekend is just one example of that. And I think we're going to have a lot of problems that are gradually going to come through, where what, as we say, started off with something of the best of intentions, does not necessarily lead to the best actual regulation enforcement that comes off it. I wish I was wrong. I'd like to be saying that this is a great model for the regulation of tech platforms, and that this will allow for our young people to grow up in a safe online environment. But sorry, UK government's track record of regulating tech does not give me the confidence to think that this is going to be any different, in the events of this weekend kind of reinforcing it. So sorry not to be more positive on this. People, including my wife, say that very often I'm too negative on these podcasts. I do try not to be. I try and be realist, and that's what I'm trying very hard to be on this occasion.
Thanks, Peter. So moving on to our next story, we are looking at the fact that 1Password was all it took to end a 150-year-old business. So essentially, 1Password is believed to have been all it took for a ransomware gang to destroy a 158-year-old company, put 700 people out of work. KNP, a Northamptonshire transport company, is just one of tens of thousands of UK businesses that are hit by such attacks. However, in KMP's case, it thought the hackers managed to gain entry to the computer system by guessing an employee's password, after which they encrypted the company's data and locked all of its internal systems. So in 2023, KMP were running approximately 500 lorries, most under the brand name Knights of Old, and the company said its IT complied with industry standards and it had taken out insurances against cyber attacks. But the gang of hackers known as Akira got into the system, leaving staff unable to access any of the data that they needed to be able to run their business. And to get the data back, the hackers said the company had to pay. There wasn't a named price, but specialist ransomware negotiation firm estimated that the sum could be as much as 5 million, which obviously KMP did not have, and therefore they were literally shut down. The company went under, and this is unfortunately a very sad case of where really simple solutions could have been made that would have had all the difference in this scenario, i.e. having really good password hygiene.
I was just about to say, and if they had a VPN, no, maybe not. I shouldn't laugh. Right, this is the reason we wanted to talk to you all about this today is because this is a really good example, a really good case study. Very often our clients will say to us, okay, we understand we need to do X, Y, Z, but can you give us an example? In particular, our multinational clients sometimes like, can you give us examples of, fines or regulation by the UK ICO that we can use that show what the approach is in the UK versus the approach in another European country, for example. And very often, because in particular of the way that the UK ICO isn't fining people in the way and volume of a lot of the European regulators, you don't get examples of here's a nicely gift-wrapped case study of here's an organization that did this, this is what went wrong, and this is why it got fined, and this is where you find it on the ICO website. So in this instance, we've got this great case study from the BBC, who have publicized the fact, basically saying this is what can happen with a really badly timed ransomware attack. Transport and logistics company, lots of not necessarily sensitive data, but a lot of communications data that they would rely on in terms of making their organization function. And in this instance, they would have evolved over time. They would have had lots of legacy systems, and in this instance, their systems were easily compromised. And in this instance, well, it's the fact that it was a password that it looks like was fairly easy to get through.
Yeah, and there's even software out there where you can input certain passwords, and it will actually give you how long it would take to crack them. And it's always quite an interesting activity to do because it is very intriguing that some people still continue to use password as a password because they think, well, people won't guess password because that. Anyway, the mentality is quite interesting.
It is.
But
now, the thing we wanted to link to here as well is the general practice around ransomware and paying ransomware. Now, we've talked in the past about the fact that, for example, the Law Society of England and Wales and the Bar Council did a joint letter to their members a few years ago, basically saying, for the avoidance of doubt, you shouldn't pay ransomware fines, and furthermore, you shouldn't be telling your clients to pay ransomware fines. And I've spoken at conferences on panels with other lawyers, and some of them have nodded sagely at me and said, oh yes, we had to advise a client to pay a ransomware fine. And you're like, you did what? And they'll say, oh, there's real reasons why you should do this. And you're like, you're making your client pay a ransom more often than not in the form of Bitcoin, which they've never, conceived of, let alone used before. You don't know where it's going. You don't know if you're going to be in breach of sanctions about the funding of organised crime, because guess what? An awful lot of the bot farms that run these ransoms are located in countries that we are not particularly on good terms with, Russia. And therefore, there's a whole litany of reasons why you shouldn't pay. And interestingly, this week, the British government has issued advice saying, it's saying this is the direction of travel. We are going to tell the entire public sector not to pay ransoms. And it's like, thank God, because the number of NHS trusts and universities and schools that have ended up paying ransomware fines is significant.
And don't forget, ransomware fines do not mean you're actually going to get the data back. Just because you pay 5 million or however much to the attacker does not mean they're actually under any guarantee to give your data back, because there is that saying, there is no honour among thieves, and that very much stands.
There isn't, though. Apparently, when you do pay the ransom, you get really good IT support from these people. It's the thing.
The irony is unmatched.
Probably significantly better than your own in-house IT function. But that's not a reason to pay it. But the point is that the UK government is now cognizant of the massive drag up to the economy of these ransomware attacks. So they're making sure this happens across the public sector. On the private sector, they're going to say that any payment of a ransom by a UK registered company should first of all be registered, and it looks like that will have to go through the National Cybersecurity Centre. And then the NCSC can at least turn around and say, right, who are you paying the ransom to? Let's check and see if you're about to breach a sanction by paying this. And also then saying, right, if you're going to do this, what data has been compromised? How are you supporting the victims of said breach, which is the thing that usually gets forgotten about? Because usually the breach is going to be either records of customers or employees or contacts. And very often, as I say, amongst a company trying to deal with this, they don't actually think about, well, what about the victims? What about those who've actually lost the data, whose data is going to be affected and whose lives will be affected by said loss of data? So this is a good thing, being positive. It is a good thing that the government is thinking about this and is issuing guidance and is trying to, I think, at least provide support to businesses and to victims of these ransomware attacks and say, this is actually what our policy is, and we don't want to be feeding the beast by encouraging more ransomware payments.
Precisely. I think that very nicely rounds off that story. So moving on to our next story, this is looking at a fee earner who has forwarded client details to his personal address. So a fee earner who emailed himself details of clients to take with him to a new job has been barred from the profession. So the individual worked on housing disrepair cases at Liverpool firm Von Turn for 5 months before leaving for neighbouring McDermott Smith. Shortly before he left, the individual accessed confidential and proprietary information and sent 50 emails with attachments to his personal email address. The attached documents including templates and workflow documents, as well as confidential client information. He subsequently forwarded a large number of the Bond Turner emails and attachments to his new work address and used some of the documents in his new role. There is a lot to unpack here, but enough to just say as a baseline, this is a data breach.
Let's begin at the beginning, though, because we've used that ubiquitous one. We've quoted here from the Law Society Gazette, the esteemed organ of the legal profession. And of course, they use the wonderful term fee earner. And I was at an event recently and I said fee earner, and someone looked at me as though I'd got 3 heads. I said, what's a fee earner? And I went, oh, it's someone that is able to charge legal fees in a law firm. So someone like a solicitor or a paralegal or a trainee solicitor, or someone who earns the fees for a law firm. That's what we're talking about when we say fee earner. And I say that because we sometimes fall into the pit of using jargon that no one else understands. So the point here is this is a practice. And it's interesting that this is a headline that's come up in the Gazette, because this is something that I think happens a hell of a lot and has done for decades, where when lawyers change firm, they take information with them. And they know they shouldn't, but they do it. And I think sometimes by doing it using email accounts, they thought they were being very, very clever. So this individual, before they left one firm, goes and forwards a load of information to a private account, a Gmail or whatever, and then forwards information from that account to their new work account. And I haven't walked out of the front of the law firm with a load of paper files under my arm. Look, I just forwarded the information via emails, and my previous employer is too stupid to look. That's generally what will have gone through the fee earner's mind, and they are doing this probably without having had the first thought to professional responsibilities. And this individual has then had the book thrown at them by the SRA, and I can't help but wonder if our fee earner, he says, putting it in air quotes, even stopped to think, ooh, client confidentiality, professional regulation, should I be doing this? And I think if they had, they probably wouldn't have done it because they'd have thought, "Oh, God, actually the risk here is way too great to be doing this. I could get struck off." And that would have overweighed the temptation to think, "Oh, I'm being jolly clever and I could take this information with them." Because, sometimes information that they think is going to be incredibly valuable, you change firm and suddenly find, oh, actually that wasn't very useful at all, but they've done it. And they've done this, and as I say, they probably didn't even think from a professional point of view. And you and I were talking before we started recording. I said, well, is this something that during your legal education training, that through your university, has at any point when it comes to professional conduct, has this sort of risk been talked about? And your answer was
no. So confidentiality is spoken about a lot, and do not get me wrong, that it is literally the baseline of every conversation. But in terms of how it actually works in practice, and actually how it kind of interacts with data protection law, not mentioned at all. And it's really interesting because you brought up, and I was like, no, we ever really considered that. And it's something that actually I think a lot of other people in other fields and sectors do, because they'll take, for example, hairdressing. You might take contacts of your clients with you when you leave to go to another hairdressing firm. Well, that's really cool. And that's actually almost kind of known as standard practice. But it is literally forwarding that information to yourself, and it breaks confidentiality.
And one of the first data protection breach cases I ever looked at was involving someone who had left a health club and taken a load of the details of customers there, taken them themselves, and then used it to start their own business, offering one-to-one coaching.
And I think,
and that ended up being fined by the ICO. So you think, well, so from that level, you realise, yes, that information and taking that proprietorial data is wrong. But I don't think, and I say, certainly this is something that in the professional, from the academic stage of legal education training, it's not happening there.
no.
And I'd take a pretty strong gamble that law firms, when it comes to their training, are not saying to their staff, as part of the data protection training, for the avoidance of doubt, this is proprietarial client data and you don't take it with you.
No.
And
that's just it as well. We don't know the mindset of this individual, but I doubt that this was done maliciously. Very often it's not done maliciously. It's just because there is not that knowledge there, or the understanding or the training to say, you should not do this. And this is, again, where we're looking at training and policy, because unfortunately, if it's not directly highlighted within a policy, and then training is not being given on it, then it's likely to fall by the wayside.
Yeah. I mean, I remember working at a city law firm, and there was a guy that had been recruited specifically because of his knowledge and expertise in a certain industry. Wasn't a lawyer, but he brought with him large volumes of information that he had been exposed to, but with his previous employer, brought that with him. And it was almost like he felt that tacitly that was one of the things he had to bring with him because that's what he was being paid for. Though I think if you looked at it in black and white as we're looking at here, okay, he wasn't a lawyer, so he wasn't subject to that professional responsibility element.
Yeah.
But was it a data breach? Yeah, it was. And again, I think those are sorts of grey lines where I think very experienced and highly qualified individuals have looked and they've not put two and two together and realised you're about to break the law here.
And this is where, there's quite a big difference to the story that we discussed before about, being an issue of a cyber attack, where this is a different sort of breach that actually comes from the squishy thing sat behind the computer, where, you've just got bad practice.
Yeah.
And actually, there is a very simple solution to the bad practice, i.e. have policy, have a clear policy, have training, and actually, there you go. This individual might have avoided some fairly steep consequences for his actions.
And this also reinforces one of the things I've always said to law firms, which is that when someone resigns, you say, thank you very much, you take their equipment, you take their passwords, and you put them on gardening leave. And the number of law firms that turn around and say, oh, well, no, we have to have them work their 3 months or even 6 months notice to have an efficient handover of all of these cases. And it's like, well, yeah, but look at the risk. How often are your fee earners then thinking, right, well, I'll take this, I'll take that, and they're taking it with them to their new firms? And you're actually giving them the tools to do it and saying, for 6 months, here's free rein, have at you. So if you don't want that to happen, I always think just close off the access and that's done. Because otherwise, as I say, you're just inviting this to happen.
Thanks, Peter. Moving on to our next story, we are looking at McDonald's AI Hiring Bot. So if you want a job at McDonald's today, there's a good chance you'll have to talk to Olivia. Olivia is not a human being, but instead an AI chatbot that screens applicants, asking for their contact information and CV, then directing them to a personality test and occasionally makes them go insane by repeatedly understanding the most basic questions. So until a few weeks ago, the platform that runs the Olivia chatbot, built by artificial intelligence software Pandora Paradox.ai, also suffered from absurdly basic security flaws. As a result, virtually any hacker could access the records of every chat Olivia had with McDonald's applicants, including all of the personal information that they had shared throughout those conversations, with tricks as straightforward as guessing the administrator's account username and passwords, such as 1, 2, 3, 4, 5, 6. That is damning. 1, 2, 3, 4, 5, 6. That's second only to password as a password. And I think we're going to see a massive increase in the use of AI screening. We only discussed this with our client earlier in the year, where they were bringing on AI as part of their application process. There are a lot of hoops and things we considered when advising them on this, but clearly there was something that went amiss in terms of the security of this chatbot.
And I mean that was for one of our clients where they have, hundreds of UK staff, probably a few thousand across the whole organisation, but they are tiny compared to McDonald's. The thing here is this illustrates how big organisations have been using AI for a long time now and are now starting to use it. As the models are getting better and more sophisticated, they're just going to give them more and more tasks. But they've been using AI as a form of being able to sift applications for actually quite a long time now. So this involved an app that had something like 64 million users on it in terms of the, historical job applications going back, where you may have a role and at a new store and then hundreds of people apply for each vacancy. So how do you sift through that? You have the AI looking at certain things and screening for certain characteristics and carrying out sift after sift after sift, and maybe even the first interview that someone has is with the AI bot. And then it records the answers and it does some more sifting before eventually it gets anywhere near a human being. It's not for us to talk about how dystopian that feels, but it's a practice that's there for big organisations, and it isn't just for those thinking, oh, well, that wouldn't happen in if you're wanting to work for a bank or a building society or an insurer or financial services or a law firm or an accountant. Guess what? Loads of them are doing it as well.
So it's definitely the direction of travel. I think we'll see more and more in the future. But the point is, if you're going to use it properly.
It'd be nice, and then again have the security in place. So. One of the things we do for our clients is putting in place AI guidelines around the use of AI to make sure that you're using systems that are safe and compliant and secure. And even then, once you've procured the right platform, that you're using it properly and having the right security measures in place and utilising it in the right way. And clearly this is not happening.
Thinking about the UK approach, they have not actually produced any actual legislation for AI, like specifically on the cover, this is AI legislation. No, they're actually saying, well, you've already got laws around data, use them. And funnily enough, one thing we've not mentioned yet, if you've got 64 million records on file, what sort of data retention period have you got if you've got that many? That's a significant amount of data that they're going to have to pay for this in some way to keep a record of that data. That doesn't come cheap.
No.
Why are they not getting rid of this sooner? So there isn't 64 million people's data available.
Exactly, and that's just it. I'm actually a fan of the approach that the UK is taking when it comes to AI, in terms of saying, look, we just want you to comply with the existing laws that you would have for any piece of tech, principally around UK data protection laws. And I always say UK data protection laws. I don't say GDPR. If you want to know why, look at the summary that we have circulated. We've spent our last podcast was all about the UK Data Use and Access Bill.
Yep.
We've put out a 4-page summary of that on our social media along with a detailed post. Just take a look on LinkedIn. Because UK data protection law is evolving and changing, but basically that is the framework you have to comply with if you're going to use AI or any piece of tech. And that's really all that needs to be done. And I'm actually more in favour of doing something like that than drafting some bespoke piece of regulation like you've got in Europe with the EU AI Act, or any other piece of legislation that ends up being too tight and just gets in the way of the good functioning of the tech, just causes more of an administrative burden, shoves up the costs of compliance, which means only the big firms can comply with it, and stops innovation, blah, blah, blah. That's a conversation for another day. But the point is actually there's, let's be positive. Let's applaud what looks like a good approach when it comes to AI regulation there in looking at UK data laws. And, saying, if you followed those well, you wouldn't have had the problem that McDonald's have had here.
Yeah, and that's just it. Do better, I think, is the kind of baseline there. Moving on to our final story of today, we are looking at the UK government's new relationship with Google. So Google has agreed a sweeping deal with the UK government to provide free technology to the public sector, from the NHS to local councils, a move campaigners have called dangerously naive. I mean, need we say more? I think dangerously naive kind of spells it out quite nicely there. But the US company will be asked to upskill tens of thousands of civil servants in technology, including using artificial intelligence, as a part of an agreement that will not require the government to pay. It is considered in Whitehall to be giving Google a foot in the door as the digitalization of public services accelerates. Sorry about the fun.
That's easy. That may be easy for you to say.
Yeah. Okay. So the agreement prompted concerns about the precariousness of UK public data potentially being held on US servers amid the unpredictable leadership of Donald Trump. And I think that's a very good place for me to stop waffling and pass over to you, Peter.
So this is an interesting story. It has an upside and a downside. The downside is passing potentially large volumes of personal data to Google, though we're told that safeguards are in place. The upside is, and again, we've talked about this on our podcast a lot in the past, about government IT having a lot of legacy contracts, old systems. We were talking earlier today actually about the fact that apparently trains in the north of England, they circulate the information on the logs and who's running on what for various reasons via fax, which, our colleague of ours who's on work experience sort of looked at us as though it's like, we may as well have been talking about sending messages via OWL at that point.
A bit more efficient at this stage.
Well, yeah, I mean, so this means, with which regards, a train company in the north of England having to research and find supplies online to keep fax machines functioning. But that's almost a parable for what things are like across the public sector, where you've got sort of old IT kit on service updates to keep it going because they can't afford to replace it because of the capital cost, or the fact that then you have to have one old piece of legacy kit to speak to another old piece of legacy kit that can't be updated. And there's all these problems across both the public sector and large organizations. And what's being said here is, look, by working with Google, we can actually start using a lot of their technology to put this information available in the cloud rather than in clunky old servers. We can have access to their kits. So, new laptops, new devices, we can use this hopefully for more efficient working. This probably will open the door to greater use of AI. The Prime Minister's made several speeches about how he wants to use AI to increase productivity across the public sector, particularly in the NHS. And this is the way they're going to try and do it. And the key thing that you mentioned there in the summary, Amelia, was that it's kind of, we're giving them access to the data. They're in theory safeguarded, so it's not like we're saying, right, Google can have a look at your medical records. But what it is saying is that this will be at minimal or low cost then to, so the government isn't having to make capital expenditure on big, expensive IT projects. Look at the history of this. The NHS was supposed to have had a big, massive IT project 20 years ago. It was authorised by Tony Blair, and they were going to spend something like 15 billion under a private finance initiative deal to update NHS IT, and it was such a massive. 15 billion is a lot of money now. It was vast in the mid 2000s when this was announced by a prime minister who, ironically, at the time didn't even use a computer. But he was put in front of one and told, look, Prime Minister, this is jolly good. And he went, oh, yes, this looks fantastic. Let's spend the money. And nothing ever came through from that. Huge amount of money spent. It didn't go anywhere. It collapsed. Now, fast forward 20 years, the government's basically saying we're going to have another tilt at this, but the risk is on Google rather than the public sector balance sheet. That's the thing we're looking at here. In terms of capital expenditure, and also then saying that we don't have to add on to a regular increase in terms of budget on an annual basis to try and do this as well. So the key they're looking for is increased productivity. We're going to use Google to do it. And Google's saying, oh, yes, we're happy to do that. And when a tech company turns around and does that, you think, yes, because they see the value in what they're getting. So that's why campaigners say it's naive. You can see, I think, positives and negatives in there. There is a big negative if you think about the risk there to personal data. Even if they take out the unique identifiers, there's certain information that could be taken and used for bulk processing that you can think, well, it might be beneficial for Google to work out, how many people in a certain region have got different types of cancer or are requiring treatment or require special educational needs support. You can imagine all of these things being something that, if you can improve the provision of support, great. But then you can think of the damage around this sort of information being shared. And when a lot of the information we talk about is, regulatory breach of the week, you can't help but see a bit of a red flag around that. So we can't make any decision in terms of is this a good thing or a bad thing, and we aren't seeking to say that. We're just setting out this story for you, which is one of those where we could look back on this and say, wasn't it a great idea? There's massively improved productivity and service provision across the public sector, in particular the NHS. Or we could be sat here in a few years' time saying, oh, look at the problems that we then had around digitisation of huge quantities of data as a result of this. It's just one of those fork in the road, the sliding doors moment. Let's now see what happens.
And that is our last discussion of the episode. So if you have any questions about what we have talked about today, please feel free to email us at admin@digitallawuk.com. A summary of today's stories are available on our website, as well as the links to the original stories containing more information. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping to produce this podcast. And if you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder, these episodes are available on our website, YouTube channel, and podcast channels such as Spotify and Apple Music. Please feel free to leave us a review, and we look forward to seeing you again next week.